The recent arrests of Azam Swati and other PTI representatives before him have all been in the guise of Section 20 of the Pakistan Electronic Crimes Act, Peca, which in at least Azam Swati's case is wholly misused and used in a way that it no longer belongs on the books of law. Peca has an interesting history in that it has had participation and input from every political party that today calls such actions draconian, whether it is suffering from them today or is the beneficiary of them today. Peca was introduced under the guise of needing an overarching anti-internet slander and revenge harassment on the internet, laws to counter such acts. It was disguised at the time of Anusha Rahman as the IT minister. It was disguised as a kind of law that protected against the harassment of women online, against the blackmailing of women through technology and through the leaking of their private pictures and their private materials, through the sale and propagation of child pornography. This was the main tenet behind putting this act to table, and it was conveniently bundled into cyber terrorism and cyber warfare. So it speaks of hacking and control or access of people's computers or systems and the illegality thereof, because Pakistan did not have laws to counter anything within the cyber realm at the time, or did not have sufficient laws, and the old criminal code didn't cut it. So here we have this bundled act that was presented as the savior of women online, the savior of children, and such heinous crimes online, and also hacking and this new world, what we like to call the fifth generation of warfare attempts online. And it comes bundled with this very nefarious understanding of defamation, where Section 20 states that where it is an offense to harass someone online, where it is an offense to invade their privacy online, it would also become an offense to harm their reputation. And this harm their reputation obviously became the state's newest weapon in its shining and draconian armory of criminal defamation, which already all around the world, because of its colonial past, is something that states have moved on from, but Pakistan has not. And it was used in that way, a weapon against free speech, a weapon against speaking against people who ought to be spoken against, speaking against departments of the government which ought to be held to account and are not. And this finally became a weapon from within the PMLN government of 2016 against themselves. And when it came time for the PTI, their government made it even stronger and more draconian through an amendment which proposed that the offense of harming the reputation of a natural person, it decided that the term natural person would include organizations such as the military or other organizations of Pakistan, thereby expanding this criminal defamation, very draconian criminal defamation, which carried strict punishment, to something where you were not only defaming people, but you could be brought to book under this Electronic Crimes Act, originally meant for harassment and online hacking, for speaking against the army. There was also another amendment the PTI tried, which was that they tried to expand the role of a complainant, where a complainant would originally, because the scheme of the law again spoke of the harassed woman or the misused privacy of a child or the abused privacy of a child, the complainant was to be a relative or a respected or trusted person. This was also expanded to include the term authorized representative, whereby clearly now if an institution such as the water board or the agriculture department, or more likely the army, had an issue against you, they could be not only a natural person, but one of their officers could be the authorized representative to carry this complaint forward. This all put together was a perfect omelette of draconian law, and it was challenged in the Islamabad High Court, which after several delays finally decided that the entirety of the amendment brought in by the PTI, which expanded the scope of a complainant and the reading of a natural person, was illegal and unlawful, and struck it off the books, and went on to rightly strike off Section 20, the part of Section 20 which spoke of harming the reputation. So it struck off the idea of criminal defamation from Peca and ostensibly reduced its scope back down to what its aims and objects were when it was being brought into law, which were clearly to protect harassment online, to protect from the abuse of a person online, to protect from hacking and such cyber warfare and cyber security risks online, and to bring down what was clearly a mutated law that was being abused. And after this has been brought, which is the position today, that Section 20 exists in a truncated form, without there being the allowance to book someone under the guise of harming the reputation of. It beggars belief how Azam Swati was arrested under this section when it no longer exists on the books.